I'm delighted to have the chance to talk with you about the United States Supreme Court. This past January, Justice Sonia Sotomayor came and spoke at Berkeley Law. Rather than do a talk, she said that I could interview her. I thought a lot about what my first question should be. And I said, so much has happened in the Supreme Court in the last couple of years. There's so much on the docket for court this term. How are you? And she responded by saying, I'm exhausted. And it's easy to see why she would say that. Think about what the Supreme Court has done in just the last couple of years. It's overruled Roe versus Wade. It's dramatically expanded the scope of gun rights. It's obliterated the wall that separates church and state. It's imposed significant new limits on the powers of administrative agencies. It's overruled 45 years of precedents that allowed college universities to engage in affirmative action. For the first time, has said that business establishments are allowed to discriminate in violation of state law to engage in expressive activity. And most recently, it said the president has broad immunity from criminal prosecution for anything done while in office. What I'd like to do is to talk with you, especially about the Supreme Court from last term. It's officially known as October term 2023, and the Supreme Court from this term. It's officially known as October term 2024. And what I thought I'd do is pose a series of questions and then provide my answers to them. First question that I want to address is, what's the overall theme to describe the Supreme Court over the last year? And my overall theme would be, it's a court divided. The Supreme Court decided 59 cases with signed opinions after briefing and oral argument. What makes this number significant that in the 1980s, the court was deciding 160 cases a year. The smaller docket began when William Rehnquist was Chief Justice. In his last year as chief, October term 2004, the court decided 85 cases. When John Roberts went before the Senate Judiciary Committee in the summer of 2005 for his confirmation hearings, Roberts was asked about the smaller docket. He lamented it. He said the court should decide at least 100 cases a year. He became chief, and the docket promptly got smaller. The court's got nowhere near to 85 cases in the years that John Roberts has been chief. Now, each term, the court is somewhere in the high 50s as the number of cases that it's deciding. Of those 59 cases, 23 of them were 6-3 decisions. 6-3 is an important number because there are 6 conservative justices appointed by Republican presidents and 3 liberal justices appointed by Democratic presidents. There are, in addition, 5-4 decisions. Of the 23 6-3 decisions, the most common split was a familiar one along ideological lines. It had a majority of Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, a dissent of Sotomayor, Kagan, and Jackson. And yet, these statistics don't reveal how divided the court was last term. Even in cases that were unanimous or near unanimous, the court still had many opinions in deep division. I'll talk about an important Second Amendment case. The result was 8-1, but there were 7 different opinions. I'll talk about an abortion case, and the court dismissed it and didn't decide it, but there were 4 different opinions and sharp disagreement among the justices. In many of the dissents, both by the liberal and the conservative justices, there was great anger expressed, sometimes even vitriol. Over a half century ago, someone writing about a Supreme Court at a time when some of the justices notably loathed one another, Jackson and Black, Douglas and Frankfurter, referred to them as like scorpions in a bottle. I'd refer to the current court as like 9 angry scorpions in a bottle. Well, let me go to a second question. What didn't the court decide this term? I think what's interesting is some of the most important issues that were briefed and argued to the Supreme Court weren't decided by the Supreme Court. Let me give you some examples of that. Let me start, as I alluded to a moment ago, with abortion. On June 24th, 2022, in Dobbs versus Jackson Women's Health Organization, the Supreme Court overruled Roe versus Wade. The court held that there's not a constitutional right to abortion. This past term, for the first time since then, the court had a couple of cases that dealt with abortion issues. What's notable is that neither of them involved a constitutional right to abortion. That was resolved in Dobbs. But both of them could have mattered enormously in terms of the availability of abortion. And yet the Supreme Court decided neither of them. The first of the cases was Food and Drug Administration versus Alliance for Hippocratic Medicine. In the year 2000, the Food and Drug Administration approved a two-drug protocol for medically induced abortions. One of those drugs is mifepristone. The Alliance Defending Freedom is a very conservative organization. It is very much against abortion rights. It filed a lawsuit in Texas federal court challenging the FDA's approval of mifepristone. They filed their lawsuit in the United States District Court for the Northern District of Texas. Why do I mention this? Well, there's only one judge in the United States District Court for the Northern District of Texas in the Amarillo Division. So they knew by filing in the Amarillo Division exactly who their judge would be. And it was Judge Matthew Kaczmarek. Judge Kaczmarek was a strong opponent of abortion rights before going on the court. The Alliance Defending Freedom didn't choose their venue by accident. And Judge Kaczmarek did not disappoint them. Judge Kaczmarek said that he wanted to refer in the opinion to it being a fetus or even an embryo. It was an unborn child or an unborn human being from the moment of conception. He said that the unborn child has rights from the moment of conception. And he said that the FDA abused its discretion, violated the Administrative Procedures Act when it approved mifepristone in the year 2000. Prior to Judge Kaczmarek's ruling, no federal court in history had ever overturned the Food and Drug Administration's approval of a prescription drug. The United States Court of Appeals for the Fifth Circuit in part affirmed and in part reversed. The Fifth Circuit said the approval of mifepristone in 2000 was too long ago to challenge now. But they said in 2017 and in 2021, the FDA changed the rules to make mifepristone more easily available. It used to take 3 doctor's visits in order to be able to use mifepristone. There's no other drug where doctor's visits are required. In 2017, the FDA changed that to 1 doctor's visit, and then in 2020, they said no doctor's visits. The FDA changed the dosage, saying a lower dosage could be used. It used to be that mifepristone had to be used in the first 6 weeks of pregnancy. The FDA said it could be used in the first 10 weeks of pregnancy. The FDA said that a nurse practitioner could prescribe mifepristone. The Fifth Circuit invalidated all of these rules. Why does it matter so much? Last year, according to the Guttmacher Institute, 63% of all abortions in the United States were medically induced rather than surgically performed. So this case is crucial as to the availability of mifepristone. But the Supreme Court dismissed the case on standing grounds. The Supreme Court did not reach the merits. The Supreme Court said no one is injured by the FDA's approval of mifepristone. The lawsuit was brought by doctors. Now, the theory of the plaintiffs, this was expressed in oral argument, was that if a pregnant person took mifepristone and the abortion was incomplete, the person would go to a hospital emergency room, and a doctor there would have to complete the abortion, even if it was against the doctor's conscience. At the oral argument, the justices asked, Can you point to a single instance where this has ever happened? And the lawyer could not. The Supreme Court said, under federal law, no doctor has to perform an abortion if it's against his or her conscience. The Supreme Court said, thus, there's no injury here. But the Supreme Court didn't decide whether the FDA rules of mifepristone are permissible. There's a lawsuit now pending brought by 3 state governments challenging the approval of mifepristone. The Heritage Foundation Project 2025 says as one of its goals is to get mifepristone in medically induced abortions off the market. So the issue is not resolved. The other case with regard to abortion that wasn't decided was Moyle versus United States. It involves a federal law, the Emergency Medical Treatment and Labor Act, often referred to as EMTALA. And it says that if a pregnant woman goes to a hospital, here hospitals receive federal funding, Medicare, Medicaid funding, the hospital must provide the care that's necessary to stabilize her condition. The Biden administration adopted rules that said that if a pregnant woman goes to an emergency room and her health would be served by an abortion, one must be provided if she desires it. Idaho has a law that says that an abortion can be performed only to save the life of the pregnant woman. Remember, the federal statute is interpreted to allow abortions if needed to protect the health of the woman, either her immediate health or her future reproductive health. A federal district court in Idaho found that the Idaho law was preempted by federal law in circumstances where federal law would say that an abortion should be provided and Idaho law would prohibit it. Where federal law would say perform an abortion for the health of the woman, but Idaho law would not allow that, federal law takes precedence. The state of Idaho went to the United States Court of Appeals for the Ninth Circuit to have it stop the judge's order. The Ninth Circuit refused. Idaho then went to the Supreme Court for an emergency stay. The Supreme Court granted the emergency stay and then granted review in the case. The case was briefed and argued, but then the Supreme Court dismissed the case without decision. There were 4 different opinions, even though the case was dismissed. Justice Kagan wrote an opinion, joined by Justice Sotomayor and Jackson, and Justice Kagan said, it seems clear that the Idaho law is preempted where it conflicts with federal law, but she said, we should send it back to the Federal Court of Appeals to decide first. Justice Jackson dissented, and she said, we should resolve this now. We say the Idaho law is preempted. We should give guidance to courts around the country. You then had a separate opinion by Justice Alito, joined by Justices Thomas and Gorsuch. And it was an angry dissent. And he said, we should decide the issue and decide it now. The Idaho law is not preempted, and we should give guidance to the country. Justice Barrett wrote an opinion, joined by Chief Justice Roberts and Justice Kavanaugh, and she said, we made a mistake taking this case before the Federal Court of Appeals could rule on it. So we're going to dismiss the case now. What do you learn from all of this? There's 3 judges who would say that laws like the Idaho one and that exist in many states is preempted by federal law. 3 justices would say it's not preempted, and 3 who didn't say. So again, what you're dealing with here is a situation of the Supreme Court not deciding an important issue. One more example of the Supreme Court not deciding an issue, and this is in the First Amendment context. It's a case called Murthy versus Missouri. Missouri, in another state, and 5 conservative individuals sued the Biden administration for pressuring social media companies take down what they regarded as Biden administration as false information. The Biden administration pressured social media companies to take down false information about the effects of COVID vaccines, to take down false information with regard to the 2020 presidential election. The 2 states and 5 plaintiffs said that the Biden administration's pressure on social media companies violated the First Amendment. What exactly did the Biden administration do? The Biden administration told social media companies that if they didn't take down false speech, they'd face more government regulation in the future. A federal district judge in Mississippi issued a broad injunction against the White House and many federal agencies from communicating with social media platforms, from communicating with internet companies with regard to false speech. The United States Court of Appeals for the Fifth Circuit affirmed. The underlying issue is an important one. When is speech by government officials without any sanctions enough to violate the First Amendment? I sent a letter to the law school community at the beginning of the school year stating our free speech policy. And in it at the end, I say, just because the right to say something doesn't mean it should be said, that I would hope that when they speak, they would do so with civility, tolerance of views other than their own, and even kindness. A student complained to me that that message was chilling speech of students. Is my speech just by itself enough to chill? That was the underlying issue in Murthy, but the Supreme Court dismissed the case on standing grounds. It was 6-3. Justice Barrett wrote the opinion for the court. Here, Justice Alito again wrote an angry dissent. Justice Barrett said, in order for someone to sue in federal court, they have to show that they've been injured, that the injury was caused by the defendant, and that a favorable federal court decision is likely to remedy the injury. She said, here, the plaintiffs can't show that anything the Biden administration did caused speech to be taken down that wouldn't already have been taken down. Social media companies engage in content moderation all the time. Facebook takes down 5,000 hateful messages an hour. All the social media companies do this. Justice Barrett said the plaintiffs can't show that they have been hurt in any way, in a way that's been caused by the Biden administration, thus no standing. Case dismissed. Justice Alito wrote an angry dissent saying, this is one of the most important free speech issues to come to the court in years, and that the court should find that the pressure of the Biden administration violated the First Amendment. So those are examples in answer to my second question of what the court didn't decide. Now let me move to my third question. What were the most important decisions with regard to changes in the law last term? And here my answer focuses on what the court did with regard to the administrative state. I think when historians look back at this era of the Roberts Court, they will say one of its important changes is with regard to the administrative state. The myriad of federal agencies that regulate so many aspects of business and even affect our lives in so many ways. In the 2 years before this one, the Supreme Court articulated a new limit on administrative agencies. The court called it the Major Questions Doctrine. The Major Questions Doctrine says that a federal agency can't act on a major question of economic or political significance without clear congressional guidance. Why does this matter? Well, in 2022, the Supreme Court said that the Environmental Protection Agency lacked authority to regulate greenhouse gas emissions from coal-fired power plants. Greenhouse gas emissions from coal-fired power plants are a major contributor to global warming. And yet, the Supreme Court said that the Environmental Protection Agency couldn't regulate this because it was a major question of economic or political significance, and Congress hadn't given sufficient guidance. A year ago, the court said that the Biden administration lacked the authority to give student loan relief. The court said this is a major question of economic and political significance. The court said that Congress hadn't given sufficient guidance. To see why this matters so much, think of the questions of What's a major question of economic or political significance? What's enough congressional guidance to meet the major questions doctrine? The court hasn't said. So there are just dozens of lawsuits challenging administrative agency actions as violating the major questions doctrine. I gave a talk last year in Washington, and some lawyers came up to me after and said their clients believe that everything is a major question of economic or political significance. And who can blame them with the lack of congressional guidance? Well, the Supreme Court went much further in this past term in limiting the power of agencies. I'll tell you about two cases. One is Loper Bright Enterprises versus Raimondo. It involves the so-called Chevron doctrine. The Chevron doctrine comes from a case in 1984, Chevron USA versus Natural Resource Defense Council. And what the Chevron doctrine says is if a federal agency is interpreting a federal statute, federal courts should defer to that agency so long as the agency action is reasonable. Let me make this less abstract. The Chevron case involved the Environmental Protection Agency interpreting the Clean Air Act. And what the court says, when the EPA interprets the Clean Air Act, say about how much of a particular pollutant can be put into the air, courts should defer to the expertise of the EPA so long as the EPA is acting reasonably. In Loper Bright Enterprises, the Supreme Court, in a 6-3 decision, overruled Chevron. Chief Justice Roberts wrote for the court. Justice Kagan wrote a strong dissent. Chief Justice Roberts said, courts are the experts in interpreting statutes. No need for courts to defer to agencies. Justice Kagan, in her dissent, said that Chevron was interpreting a federal statute, the Administrative Procedures Act. If Congress didn't like Chevron deference, at any point in the last 40 years, Congress could have amended that statute. But she said that really Chevron was right, that agencies are the experts. Courts should defer to their expertise. Those regulated by federal agencies have long wanted to see the Supreme Court overrule Chevron deference. Makes it much easier to challenge administrative actions in federal courts and have them overturned. I predict we will see an enormous increase in challenges to agency actions now that there's no longer Chevron deference. One more case about administrative agencies, and then I'll try to pull this together. The case is Securities and Exchange Commission versus Cherkesy. George Cherkesy and his business, Patriot 24, were under suspicion for securities law fraud. The matter was assigned to an administrative law judge in the Securities and Exchange Commission. The judge found against Cherkesy and his business. The Securities and Exchange Commission agreed with the administrative law judge. It imposed a $300,000 fine, civil penalty on Cherkesy and his business. It imposed restrictions on how he could do business going forward. The Supreme Court said it violated the Seventh Amendment to have the Securities and Exchange Commission impose the penalty rather than it going to federal court where there could be a jury trial under the Seventh Amendment. Here too, Chief Justice Roberts wrote for the court and Justice Sotomayor wrote for the dissent. Justice Sotomayor said there are countless matters where Congress has assigned things to federal agencies, including imposing penalties. If somebody has a dispute with the Social Security Commission over benefits, it goes before an administrative law judge in the Social Security Commission. This is going to require, at least if it comes to fines and penalties, it all go to federal court. But Justice Sotomayor in her dissent also said there are some agencies that have authority under federal law to impose fines themselves, but have no authority to go to court. To pick an important example, the Occupational Safety and Health Administration can impose penalties, but it has no authority to go to court. Does this mean that it's a statute that's not enforced at all? So what's going on? I think what we're seeing is a very significant shift in power from federal agencies to federal courts. The major questions doctrine makes it much easier for courts to overturn agency actions. The end of Chevron deference, much easier for courts to overturn agency actions. Jerkezi requires matters be in court rather than administrative agencies. The larger significance is enormous. Since the 1930s in the New Deal, it's always been thought that Congress needs to give broad delegation of power to agencies. The Securities and Exchange Commission, the Federal Trade Commission, the Occupational Safety and Health Administration, and so on. And that courts should defer to agency expertise. The court no longer believes that there should be broad delegations of power. It no longer accepts the premise of agency expertise, and it rejects the idea of judicial deference. I think we're just seeing the beginning of a court dramatically reshaping the administrative state. Fourth question about the term. What was the case with the greatest practical significance last term, especially for those in California? And without hesitation, I would say it was the decision in City of Grants Pass versus Johnson. The City of Grants Pass is in southern Oregon. It has an unhoused population greater than the number of shelter beds. Grants Pass adopted a series of 5 ordinances that ultimately made it a crime for a person to sleep in public. In fact, one of the ordinances made it a crime for a person to have a blanket or cardboard or pillow for purposes of sleeping in public. The United States Court of Appeals for the Ninth Circuit declared this unconstitutional as cruel and unusual punishment. The Ninth Circuit said, everyone has to sleep. If there's not adequate shelter beds, a person has no choice but to sleep in public. To penalize people who do that is cruel and unusual punishment. And in Robinson versus California in 1962, the Supreme Court said the government can punish conduct, but it can't punish status. The United States Supreme Court, in a 6-3 decision, reversed. Justice Gorsuch wrote for the court. Justice Sotomayor wrote a blistering dissent. Justice Gorsuch's majority opinion said, the Eighth Amendment prohibition of cruel and unusual punishment applies only to limit the type of punishments that can be imposed, like when and whether the death penalty imposed, or the length of sentences for crimes. He said the Eighth Amendment doesn't limit what crimes can be punished by the government. That's flat out inconsistent with Robinson versus California and other precedents. He said here, Grants Pass isn't punishing the status of being unhoused. Grants Pass is punishing the conduct of sleeping in public. And the court said that Grants Pass may do that. The court concluded its opinion by saying that the problem of homelessness should be solved in the political process, not in the courts. Justice Sotomayor, as I said, wrote an angry dissent. She said, sleep is a biological necessity. If there aren't adequate shelter beds, then a person has no choice but to sleep in public. She said, what the government is doing here is very much punishing the conduct, not punishing the status of being homeless, not conduct. Perhaps the most famous line from Justice Sotomayor's dissent is where she said, the message of the majority to the unhoused is, quote, stay awake or be arrested. Case has had huge practical effect here in California already. Immediately after the case came down, California Governor Gavin Newsom said that he wanted unhoused individuals cleared off of state property. He encouraged counties to do the same. Governor Newsom in Los Angeles participated in clearing some unhoused individuals from under an overpass in the 10 freeway. Some local governments are aggressively using their criminal law against the unhoused. Others, like Los Angeles, Mayor Karen Bass said they're not going to use the criminal law. The Los Angeles County Board of Supervisors said it doesn't want to use the criminal law. To start with, It's unclear how arresting and criminally prosecuting unhoused individuals does anything to solve the problem of homelessness. Briefly putting an unhoused person in jail and then returning them to the streets doesn't do anything with regard to homelessness. The real need is having places, adequate shelter beds for the unhoused. I think there's a lot of legal issues that are going to come up. When police arrest unhoused individuals, they generally destroy the possessions or take them away. Is that a violation of the Fourth Amendment or taking your property without due process or just compensation? I think what we're seeing is enormous pressure on cities. Um, you might have seen a story that it was front page of the Los Angeles Times that some Burbank police took some unhoused individuals and just dumped them in the front of the house of the president of Los Angeles City Council. Um, I worry that cities are going to try to move their unhoused to other cities. San Francisco Mayor London Breed told San Francisco police that she wanted unhoused individuals to be offered bus fare to leave the city, and if not, to arrest them. But where will they go? It's something that desperately requires a state solution. It's not something that's going to solve at the city level. Maybe it'll come through the California legislature. Maybe it'll come from the California Supreme Court. Fifth question. What was the most important case with regard to constitutional interpretation from last year? And here, without hesitation, I'd say Rahimi versus United States. It involved the Second Amendment. From 1791, when the Second Amendment was ratified, until 2008, the Supreme Court never struck down any federal, state, or local gun regulation as violating the Second Amendment. In the handful of cases about the Second Amendment, the Supreme Court always said, the Second Amendment means what it says. It's a right to have guns for the purpose of militia service. But in June 2008, the Supreme Court shifted course. In District of Columbia versus Heller, the court said that the Second Amendment protects the right of people to have guns in their home for the sake of security. But that's as far as the court went. Then, in 2022, in New York State Rifle and Pistol Association versus Bruin, the court said that the Second Amendment protects the right of people to have guns in public. That case involved a New York law, it was over a century old, that said in order for a person to have a gun in public, they needed a permit. In order to get a permit, they'd have to show a safety need, a reason to have a gun in public. The Supreme Court 6-3 declared that unconstitutional. And Justice Thomas, in the majority opinion, said the only kind of gun regulations should be allowed are those that were historically permitted. Justice Barrett, in a concurring opinion, said, we haven't decided whether historically permitted means in 1791, what includes 1868, when the 14th Amendment was ratified. Well, this has led to challenges to every imaginable kind of gun regulation. The first of the cases to come to the Supreme Court since Bruin in 2022 is United States versus Rahimi. It involves a federal law that makes it a federal crime for a person under a restraining order in a domestic violence case from having a gun. Zacky Rahimi was seen seriously beating, abusing his girlfriend. When someone tried to help her, he fired a gun at them. The girlfriend went to Texas State Trial Court and was able to get an injunction, an order against Rahimi that said he couldn't have any contact with the girlfriend or her family for a 2-year period. When the judge issued the order, the judge said to Rahimi, and as a consequence of this order, you can't have a gun for the next 2 years. That's what federal law says. Rahimi was then the suspect in a number of other shootings. Police got a search warrant for his home. When they were there, they found a large number of guns. Ironically, with them, they also found a copy of the judge's order that he wasn't allowed to have guns. Rahimi got prosecuted under the federal law that said a person in a restraining order in a domestic violence case can't have guns. The United States Court of Appeals for the Fifth Circuit declared that federal law unconstitutional. The Fifth Circuit said that in 1791, when the Second Amendment was ratified, there was no law against people under restraining orders, domestic violence, kidnapping, guns. So therefore, this is unconstitutional. Of course, tragically, in 1791, there weren't laws against people having, there weren't laws against domestic violence. There weren't restraining orders against domestic violence. The Supreme Court, in an 8-1 decision, reversed the Fifth Circuit. Chief Justice Roberts wrote for the court. Only Justice Thomas dissented. But what's interesting, as I alluded to in my introduction, is that there were 7 different opinions for the court. Chief Justice Roberts' majority opinion said that in interpreting the Second Amendment, we focus on history and tradition. In this way, the decision very much followed from Bruin. There was not a word in Chief Justice Roberts' opinion about why this federal law is important to save lives, especially to save women's lives. He said, though, the Second Amendment was not frozen in amber. He said in 1791 that it was a court determination that somebody was dangerous, they could be kept from having guns. And he says that's a close enough analog. But I want to stress that the court continues to use the historical approach in deciding what gun regulation allowed, paying no attention with regard to how important the law is now. Justice Thomas, in dissent, said, as the Fifth Circuit had said, there weren't laws in 1791 keeping people under restraining orders, domestic violence, kidnapping, guns. Therefore, this should be deemed unconstitutional today. What's interesting is there's 5 other opinions debating over how the court should be originalist. Justice Gorsuch agreed with Justice Thomas that there should have to be a specific kind of law in 1791 to allow gun regulation now, but he thought there were such laws in 1791. Justices Barrett and Kavanaugh said, we have to follow the original meaning of the Constitution, but you don't need exactly the kind of law in 1791 as exists here. So long as there's a close analog, that would be sufficient. Justices Sotomayor and Jackson wrote opinions saying, Bruin was wrong. We shouldn't just look to history and tradition with regard to guns. This law saves so many lives. That should be enough. So what's the bottom line? The Supreme Court upholds this federal law, but the Supreme Court continues to say that the only kind of gun regulations that will be allowed are those that were supported by history and tradition. Sixth, what were the cases involving Donald Trump? This year, there really was a Trump docket in the United States Supreme Court. And there were 2 cases that had great political significance. The first of these is Trump versus Anderson. Trump versus Anderson involved Section 3 of the 14th Amendment. Section 3 of the 14th Amendment says that if a person has taken an oath to uphold the Constitution, and then they participate in rebellion or insurrection, they can't be a senator or representative, an elector for president or vice president, or hold any civil or military office of the United States. In December 2023, the Colorado Supreme Court, in a 4-3 decision, found that Donald Trump was disqualified from being president by virtue of Section 3 of the 14th Amendment. The Supreme Court reversed. It was an opinion of the court called a per curiam opinion, rather than any justice being identified as author. Justice Barrett concurred in part and concurred in the judgment part. Justice Sotomayor, Kagan, and Jackson concurred in the judgment, but it read much more like a dissent. The Supreme Court gave 2 reasons why Section 3 of the 14th Amendment didn't disqualify Donald Trump. Whatever your views of the merits of the case, I find the 2 reasons given to be quite questionable and not persuasive. One thing the court said is, we don't want states to enforce Section 3 of the 14th Amendment. The court was concerned that there could be inconsistencies among the states. One state might allow someone to be a candidate, but other wouldn't. The problem with this argument is that it wouldn't be the state that would decide ultimately whether somebody was disqualified. The Supreme Court would review the matter, and it would decide for the entire country. The Supreme Court in this case could have said, Donald Trump is disqualified by virtue of Section 3 of the 14th Amendment, in which case he would have been disqualified everywhere in the country. Or the court could have said, Donald Trump is not disqualified, and he could run everywhere in the country. State courts enforce the 14th Amendment all the time. Yes, of course, a case arises in a state, but ultimately the Supreme Court would decide for the whole country whether Donald Trump or any candidate was disqualified for the whole country. The other argument the court gave was to say that it should be for Congress to enforce Section 3 of the 14th Amendment. Court shouldn't do it. But why not? Courts enforce the other parts of the 14th Amendment. There are other disqualifications on who can be president. You have to be 35 years old, have to be, quote, a natural-born citizen, can't have already served 2 terms. Courts enforce these. Why not Section 3? Perhaps most important, Section 3 in the last sentence says Congress can remove the disability by 2/3 vote of both houses of Congress. Why doesn't that specify what the framers thought Congress's role would be? The other case was Trump versus United States, decided on July 1st of this year. The special counsel, Jack Smith, had a grand jury in Washington indict Donald Trump for his role in trying to undermine the results of the 2020 presidential election. Trump moved to dismiss the indictment, saying that everything he did was run the White House, and a president can't be criminally prosecuted for anything done while in office. The federal district court rejected this argument. The United States Court of Appeals for the District of Columbia Circuit rejected this argument, but the Supreme Court accepted it and reversed the lower courts. Again, it was 6-3. Here, Chief Justice Roberts wrote for the court, and Justices Sotomayor and Jackson each wrote dissents, joined by Justice Kagan. I think the majority and the dissent start from such basically, fundamentally different positions. The majority starts with the premise that the Constitution was meant to create a vigorous executive. Chief Justice Roberts says that the president is the only instance where one person is a branch of government. The majority is afraid that allowing criminal prosecutions of former presidents will chill conduct in office. The dissent starts from a very different premise. The dissent says that the core of the rule of law is that no one, not even the President of the United States, is above the law. The dissent was concerned that this does put the president above the law. From the dissent's perspective, if anything is clear about what the framers wanted, it was to reject royal prerogatives. Chief Justice Roberts, reasoning from his premise, says there are 3 zones of presidential power. First, there are official acts taken pursuant to a constitutional or statutory provision. The court says for this zone, the president has absolute immunity from criminal prosecution. That can't even look to the president's motives in acting in this zone. Can't use anything done in this zone to establish liability in other zones. Second, there's what the court calls the outer perimeters of a president's power. The court doesn't define what's outer perimeters, but the court says in this area there's a presumption of absolute immunity, but the presumption can be overcome. But the court doesn't say what's enough to overcome that presumption. And third, the court says there's a zone of private activities of the president. It's not official duties, it's not at the outer perimeters of presidential power. And as to this, the Supreme Court says no immunity. I mentioned Justice Sotomayor writes a blistering dissent. Her and Justice Jackson's dissent are as strong as any dissenting opinion she'll see. Justice Sotomayor gave some examples. There were ones that had been mentioned in oral argument. She said, imagine the president calls out the Navy SEALs to assassinate a political rival. Since the president using powers as commander-in-chief, absolute immunity. She said, imagine that the president orders the Justice Department to prosecute somebody for retribution. The court said, Justice Sotomayor said, absolute immunity. Imagine the president takes bribes to issue pardons, because the president has the power to issue pardons. absolute immunity. She said, as to each of these, at the end of the sentence, immune, immune, immune. As you know, usually justices, when they dissent, conclude, respectfully, I dissent. Justice Sotomayor, dissenting, ended it by saying, with fear for the future of American democracy, I dissent. Justice Jackson wrote a similarly powerful dissent. I thought particularly important in dissent was a footnote. She said, no one here disputes that the president has the constitutional power to fire the attorney general. The issue in this case is, if the president would order the attorney general assassinated, is the president protected by absolute immunity? Justice Barrett, in her concurring opinion, said that she thought the court could decide the case more narrowly. It certainly could have, but what it did was write a very broad opinion, expansively giving the president absolute immunity from criminal prosecution. Seventh, and finally, what's on the docket this term before the Supreme Court? As I'm speaking, about 2/3 of the docket is set. The court will grant review in additional cases between now and mid-January that all will be decided by July 1st of 2025. It's interesting, there are fewer blockbuster type cases on the docket this term than what we've seen in prior years. Maybe the court is leaving room on its docket to hear election-related cases. And I'm recording this before the election, and so there's no way to know at this stage whether or not there will be election-related cases. I think so much turns on how close is the election, how much does it depend on one state, what are the legal issues. In 2000, the court played a decisive role in Bush versus Gore with regard to the election. In 2016, the court didn't play much of a role. But what are some of the other issues before the court? Some of them are very much rising from the culture wars. Scrimetti versus the United States, that'll be argued in December, is such a case. Tennessee adopted a law prohibiting gender-affirming care for transgender youths. They can't be prescribed puberty blockers, for example. A federal district court declared this unconstitutional. The federal district court said that this is interfering with the right of parents to make medical decisions for their children. It violates equal protection for transgender individuals. The United States Court of Appeals for the Sixth Circuit reversed and upheld the Tennessee law, and it's now before the court. The underlying issue is laws that have been adopted in many conservative states, like the Tennessee one, prohibiting gender-affirming care. There's also the question the Supreme Court's never directly confronted. How are transgender individuals be treated under the Equal Protection Clause to the Constitution? Another case, the oral argument date hasn't been set, is Free Speech Coalition versus Paxton. Texas adopted a law that required that any website with more than a third sexual content do age verification. It also required that certain warning labels be posted, such as watching pornography is addictive and harmful to your health. The United States Court of Appeals for the Fifth Circuit upheld the age verification but found the warning labels to violate the First Amendment. As to age verification, the court said government regulation of sexual speech should be allowed so long as it's reasonable. That's the issue. What's the standard here for government regulation of sexual speech? The court has been quite inconsistent about this over the years. There's a Supreme Court case where it struck down the Child Online Protection Act. The case was called Ashcroft versus ACLU. It was a law that required age verification for adult websites. The Supreme Court found this to violate the First Amendment. There was Brown versus Entertainment Merchants a decade ago, where the court struck down a California law that required that those under 18 have parental consent before renting or buying a violent video game. The Supreme Court spoke of the First Amendment rights of those under 18 and struck down the law. On the other hand, there was a case in 1968, Ginsburg versus New York, that involved a New York law that said in order to buy sexually explicit material, this is really about magazines, somebody had to be at least 18, and the court upheld that. How will the court treat this case? And what will it mean for the content of sexual speech on the internet? The Supreme Court this term has some death penalty cases, something it hasn't had for a while. There's Glossop versus Oklahoma. If a state concedes that a mistake was made and agrees that there should be a new trial for the defendant, in a death penalty case, is this required? Can an execution go forward over the state's objections? What's involved here is an individual is convicted and sentenced to death. Subsequently, a good deal of evidence came out that the person was actually innocent. Turns out that the state failed to turn over to the defense a lot of material that was constitutionally required to provide. So the state of Oklahoma has taken the position that Glossop is entitled to a new trial, having provided all of the relevant information. The Oklahoma Court of Criminal Appeals disagreed. The Oklahoma Court of Criminal Appeals says that Glossop had already exhausted all of his appeals, so he can't go any further, and that therefore he should be executed. If the state concedes error, does it violate the Constitution to nonetheless execute a person? Or can the court say that the person is not entitled to any more procedures in courts, and as a result of that, allow the execution to go forward? These are just a few of the important cases that are before the Supreme Court this term. So I've reviewed for you what the court did last term. I've highlighted some of what's on the docket this term. I think the one conclusion that's inescapable is this is an amazing time in the United States Supreme Court. Thank you.